Mr. McArthur, you've said that the AP is not engaged in communicative activity when they're inside the Oval Office. So how should we understand what they're doing? Should we understand it as news gathering?
So
Or some
if I said that I
How should we
misspoke.
understand it?
The district court found that they were engaged in communicative activity because they could send essentially in real time things out like texts and pictures. But I really don't think anything turns on that analysis here. I don't think the analysis would be any different if the rule in the Oval Office were no internet.
Right.
You can come in, you can observe, you can take notes, you can take pictures, but you can't transmit anything until you leave. I think if that were the rule, they would be making the exact same claim. We would be making the exact same defense. So I don't think anything turns on that. But I do think we are not restricting their ability to communicate, or at least we're restricting it only in the sense that we are denying them access to information.
So that's what I'm wondering though. So putting aside the access to the internet, if they're just observing, and there's probably no communication, and then they're doing something like news gathering. Does that activity have any First Amendment protections?
Yes, I think that is what this court in Price talked about as sort of a pre-communicative step in the creation of speech. I think it does have, it is First Amendment protected activity.
To agree with the government's position here, would we have to say that news gathering is not covered by the First Amendment?
Not at all. Not at all. I think you would have to say that in these particular circumstances where you're talking about access to a space that's in the president's immediate periphery, that his interest in autonomy, just like in who he reveals his mind to, override any First Amendment interest in access to him to observe him up close personally and record what he is doing and saying so that you can later report it. They can't force the president to answer their questions just because
they're not claiming that they have any right to force the president to answer their questions.
That's
Or
right.
that they have any right without, very exhaustive security examination, or that they have any right to say anything disruptive or distract him from his work, or that they have any right as the press pool as a whole to be invited at moments when the president wants to concentrate on his writing and his work. So it's a little unclear to me when you say a right of autonomy. I think the Oval Office suddenly seems like a place of silent retreat. And it's clearly not. I mean, he has a private study, and as I said, he can exclude people when he thinks his autonomy so requires. People as a whole, but not based on viewpoint. So I guess I'm trying to understand the connection between the claimed prerogative to do not exclusion of humans or of members of the press, but of people because of their viewpoint. How is that more challenging to the president's autonomy than just the ability to say nobody today at all?
Because the president has speech and associational rights of his own, right? And so if you're looking at, can the president decline to answer any questions from the AP because he disagrees with the AP's editorial choices? Everyone agrees the answer to that is yes. The question is why? I think the answer is because the president has autonomy over his mind and who he chooses to reveal that information to. That is absolutely.
Is the same thing true of a mayor and a governor?
I think the same thing would be true of other government officials.
Oh.
And the information.
Cabinet secretaries.
On this point, yes. When you're talking about what's in their mind and whether they have to reveal that to someone or who they admit.
Nobody's saying that the president has to reveal anything he doesn't want to reveal. It's only about whether somebody is allowed, when the president decides we're going to have a press pool, allowed, notwithstanding viewpoint, to be a participant in that at the times when the president chooses to have the press pool present.
What I'm trying to explain, Judge Pillard, apparently not very successfully, is that it's the same principle. The same principle that says the president can consider Viewpoint in deciding to whom he discloses his mind should apply to this adjacent situation of whom he admits to his immediate periphery in private, personal, proprietary, whatever adjective you want to use to describe it, those sorts of spaces. He has associational rights just like he has speech rights.